So a very good afternoon to all the innovators of India. Uh, it's great to see you all, that you all have gathered here to learn about the management of IP assets. So I just want to say, because we all are innovators, and day by day we are innovating something, and somewhere we are contributing in the steps towards Atmanirbhar Bharat, that is Make in India initiative. Because what we invent, what we innovate is somewhere very useful for the society. We can make it available to the people at very affordable cost, at a very innovative solution that may not be useful not fully for India but for the world. So if you are innovating something, because we Indians are full of good ideas, we have good potential, we are hardworking, and can really develop our products, our novel concepts into some very useful products. And such products must not be inside some thesis or some publication. Yes, it should be, but along with that, it should have some revenue generation capacity. So, for revenue generation, we acquire the patent rights. That's for sure. And there are many kind of IP that support us to protect our inventions from getting infringed. And we also want a monopoly. So why monopolies? Why? Because we have putting so much of hard work, efforts, money, everything towards some inventions to innovate something. So government gives us rights so that it could be monopolized for some period of time, so that we can ourselves only can produce it. And yes, that is also very necessary to promote the research and development in our society. So managing intellectual property, why this is very important? Acquiring is important, yes, we should get our rights of patents. Our IP assets should be effectively utilized, and the various means through which it could be acquired is by acquiring the trademark rights, patent rights, domain names, trade secrets, industrial designs. Others are like copyright, Plant Variety and Farmers Act, geographical indications, semiconductor integrated circuits. There are many kind of IP rights. So there are many ways, many acts, laws such as Patent Act 1970, Trademark Act 1999. So all these are governing some rules and regulations through which the innovations are monopolized, or we can say the rights are given to the innovators to sell the product, import the product by their own names, and can generate revenue. This is a really service to the nation, and for that government has given so much of facilities, like all are at very reduced fee of 80% reduction for individuals as well as for startups, as compared to the normal companies. So in almost all the IP rights, there are lot of discounts, lot of fee reductions, so that every innovator should get a chance and opportunity to apply for the patent and to acquire it. So suppose once we acquire the IP rights with us, then the journey starts. So whenever we have a patent granted in our hands, we have a trademark registered in our names, we have a copyright. So we shouldn't stop there. We have to actually utilize those rights, and those rights must give us some value in future. Otherwise, government may intervene and may say us to give the rights to another, because once we acquire some right, it's our duty to use it for the service of the nation. So one thing is important is like how we protect our intellectual property. So intellectual properties, as we have just seen, patent, copyright, trademark, whenever we acquire it now, the strategy should be to protect it for the future. So we shouldn't infringe others' patent. Others must not infringe our patent. We shouldn't enter the like area of or domain or trademark of some other. Some other must not be. So we should have an independent status in terms of maintaining our IP rights. This is important because to avoid the infringement, to avoid the copying by mistake might be there, not intentional also. And we should have our own rights with us. So patent rights or trademark or copyright, once we acquire, we have a certain period of monopoly of making it, selling it, using it, importing it. And whenever we are infringing somebody, somebody can sue us, or we can also do the same. But what is important? Whenever we acquire a IP right, important is to either use it or otherwise we might lose it. So in terms of trademark, suppose trademark is granted to some person. So the owner have 5 years right from the date of registration to start using their mark. Suppose some innovator has innovated something, their company is registered, but they are not in a position to use it perfectly. Means like suppose McDonald's arc or Godrej symbol, if they are not using it, how to use them? Means like your product must carry such marks, such slogans. So if suppose products are not being commercialized extensively, it may be the situation that the innovator might not have used the trademark for 5 years. So in such cases, cancellation action can be taken place, and somebody else can register such kind of trademark in their own name. So whenever we own a right, we should start using it. Otherwise, there are many chances that you may lose the rights. Even after have a patent granted, even have a trademark registered, this may happen. In terms of patented invention, the government has a very strong rules and regulation in terms of patent. Like if you have a patent rights with you, you should start commercializing your product. If it is not well commercialized, if it is not made sufficiently in certain countries, or if it is being manufactured outside India, if you are not giving employment to the people of India by manufacturing your own product, then government may intervene. So if your patent is not working of patent statement is must. That has to be given by every innovator with a patent right. Then in such case, government may give compulsory license to some other company. License means the innovator has to give the license to some other company to make use of their own innovation. In return, they can receive some royalty. So that is the scenario. So in such cases, government may say any other company to prepare the product, and in that case, the formula has to be shared to other firm. So it simply means that once we have a patent right, we should start using it extensively. Trademark has some pros and cons in terms of like somewhere some trademark has a level of distinctiveness, market power and capacity. So sometimes our very weak mark may become very strong because they are being used by many people. Sometimes mark may become weak because of it become a generic term. So suppose just for example, this word Xerox. Xerox is a company, but this has become a very generic word. People treat it like go and I'm Xeroxing it or get it Xeroxed. So it's actually photocopying. Photocopying is the correct word, but we use the word Xerox. Xerox is nothing but actually a firm which has a machine first invented for photocopying the documents. So the same way Coke, sometimes we say that give us a Coke in case of cold drink. So it become a very generic term. So in such cases, Coke may lose their rights because it become a very general term, iPod in Ferrari. So these are some type of words that have lost its own trademark power, and it has become a generic word. So how to then control all such things? Because if suppose my trademark is becoming generic or I'm losing my rights, so in such cases we have to become our own watchdog. Means like we have to keep an eye on the market, and we have to see that what is other marks are available and are they very similar to our own mark. Suppose my own product has certain kind of logo, slogan, words, or some kind of like symbols to represent our own identity. If somebody is imitating the identity or copying the identity by using the same kind of slogans, marks, then people may get confused either by words or by pronunciation, and they may like get confused like it's my product but actually it's not mine. So what can happen, either the other product, if they are not good, they may we may lose our own reputation because people are buying because thinking that it's our own product but it's not us. So it's important that we have to monitor the market, who is selling the product, who is bearing the same mark, same kind of shapes, and how we can lose our reputation. So we have to see the press, social media, website of other companies. So every firm has a special monitoring cell, legal cell, which monitor all kind of products which are similar to us. And in such cases, if it may be there that they are using some marks or some slogans similar to us, we can catch hold them, and definitely there are legal proceedings. So in which through which we can really prevent others. There are many online tools to monitor the market. Google alerts are there. So suppose something is coming which is similar to ours own brand, then it could be highlighted and it could be said to us. So nobody should attempt to take up our own mark. There are many examples like this in such cases. Suppose in drugs also. So what is there? Suppose diclofenac, dicamol or diclamol, some kind of words are there. If it is an OTC drug, people can go and buy. So, and suppose the other product is not so good, the first one that was actually maintaining its reputation may lose it because people get confused. So, enforcing IPR is very fundamental. It's a valuable source of revenue. And yes, suppose somebody else has taken the same kind of words as our own product and people are buying in confusion, we are losing our revenue. So we have to be really a watchdog in that. So every company must have a legal section, every startup company especially because they are new and not very known. So in such cases, some really similar products may be launched in market. So where the IP is getting violated, it has to be critically monitored on the sites. Now, what is important? It's like IPR must be registered first before using. We cannot use any logo, any design, any style unless until we register it. So, whenever any company or any product is in market, every mark, every kind of their, whether it is a word or it's a mark, something, it must be registered. Their name should be registered. Without registering our trademark or without registering our design, our patent, we cannot launch, we cannot enter the market because others who are already in market, the giants or smalls, whatever, they may sue us for infringement. So it's important that once we make our mark more popular, it become more and more strong. Suppose can dare to copy the Godrej mark because it can be easily identified. It's much popular. Even normal people know how it's a signature mark actually Godrej, but everybody knows that how it looks. So normally confusion is less. But if somebody had just entered the market, there are chances that similar products should be there. So it's important that we have to be our own watchdog. We have to see what is the currently available drugs. And yes, once we have registered our trademark or patent or design, we should use the word. Suppose this copyright should be like this trademark TM, ID or registered patent. If a patent is registered, we have to write the word registered patent, and we have to see that if such marks are with us, then we are showing yes, rights are with us and nobody can use that. This is just a kind of warning symbol. And then we have to monitor the market, we have to defend our own rights, and then once we see that somebody is taking or operating using the same kind of products, then we have to fight back. Definitely all the legal proceedings will be in our favor because we have launched it first, we have the IP rights. So we can easily sue the other party. And if the IPR is registered, any company can easily win a case. So those who have an IPR registered are the owners, legal owners. Important is that for trademark, always use, once you have registered your trademark, use the word TM or R, ID, registered design, registered patent. This word has to be written on the product. And for copyright, which are registered, this particular symbol has to be there. Powerful warning message. This is the powerful warning message. I am the owner. I have my patent registered. I have my design registered. So nobody should use it, first of all. So we are protecting it by giving a warning. Another one very important thing, if we have applied for a patent but not registered, not granted, then we are not supposed to use the word registered, or we are not supposed to use the symbol R. If IPR is simply applied, we can write patent applied, but we cannot use the word registered unless until we get the grant of the patent. Now, important is what? Suppose some trademark, as you all know, what are the trademark? McDonald's name, Adidas, Godrej, all are the trademarks. They could be even slogans. They could be even a word. They could be even a symbol, a picture. Anything could be there. What is important here is like somewhere, suppose we have a domain name. Suppose it's www.google.com or marutisuzuki.com. So this is a kind of domain name that every company normally uses it. This particular word is a trademark of that. So somebody, if they are using some unauthorized use of similar kind of domain, it's a kind of cyber squatting. So suppose I'm using my own company name by some domain, and somebody is taking some words and trying to launch their own domain just to confuse it. So why I'm using some other domain name? Because just to create a confusion. Suppose if I'm using my own domain as maruti.com. So people may get confused that this is the Maruti Suzuki, and somewhere they try to open the website, they try to see that. So I just want to attract the consumer just by confusing them with by using some of the text of some very popular domain name. So this is called as a cyber squatting. This is a very regular practice in case of like companies which are small and just try to somewhere take up. This is a wrong practice actually. So typo squatting, sometimes you can suppose registering starbucks.org. So Starbucks is a very famous brand, and I'm using this word to create my own website. Yeah, I'm not related to anything which Starbucks sells, but I have just added the word org and launched my website. So people will normally get attracted. Okay, let's see what's inside. So this is a kind of like some kind of confusion created due to phonetic similarity with the words already in the domain, and they are very popular. So in this way, typo squatting is a major kind of domain, which suppose if not managed well, may lose the reputation of already very reputed firms, or they may reduce the revenue generations too. So suppose these are some examples. You can see gmail.com in place. This is the typo squatted websites. Weather.com, walmart.com, that was very popular. This is very similar, walmart.com. So people may suppose in both are shopping sites, so people may enter this site instead of actual website and may even buy something from this website. So this is a situation where actually they are reducing the revenue of actually owners of the genuine products. So we have to be very particular. This is very important. Amazon.uk.com, Amazon.uk.uk. So this is the actual, but people may be surprisingly using this because this looks more genuine. So it's very important that every, suppose not only a company, even a startup should always think of what is similar to them. It's already in the market. And yes, you can definitely sue them. There are various ways by which it could be there. Some examples more. Suppose Nishan Motors versus Nissan Computer. Nissan Motors, we all know. Nissan Computer is also there. So most people immediately think of cars when they hear the name Nissan. And this is understandable since the company has used the label since 1970. This label is there. But you know, Nissan.com was registered as a Nissan Computer Corporation, and this was 5 years before the automobile company decided to that they wanted the domain. So Nishan also wanted the domain of Nishan.com, but Nishan.com was already registered by a computer company. So Nishan couldn't open their own website using this particular domain name. So this is the beauty of domain, that once it is acquired, it is legally accepted by the government and nobody else can use the same domain name, even a big firm. Microsoft versus Microsoft. This is a kind of actually a person, Micro, who has set up a particular company with this domain name in 2003 and promoted his web design services. He had a web design service. And but what has happened? There is already very popular brand of Microsoft. And since the domain could be phonetically confused with Microsoft.com, the larger corporation, that is Microsoft, requested to transfer the domain name, and they offered $10 for the price of the original registration. But Roe, the particular person, demanded this much, $10,000 for the domain. Microsoft sent a cease and desist letter accusing him of cyber squatting. So earlier they tried to settle out, but then the person, they thought that Microsoft is such a big company, they can pay me anything to transfer the domain to them. So in such case, they asked for much more than required, and then Microsoft sent a cease and desist letter. in that. So this is how the legal proceedings start. Then Microsoft won the case. So this is the scenario where actually the typo squatting is creating so much of legal cases inside, like India, world, everywhere. We can say Amul. Amul brand everybody knows. Amul is India's leading brand in dairy companies and has a sales turnover of very high. But the company became the victim of cyber squatting. How? Because people have used many of the similar words in their domain, such as amuldistributor.com, amulboard.com, abufran, many kind, amuldistribution.com, kind it. As a part of their scam, what has happened? They made bogus bank accounts using Amul name, sent fake forms via emails through Amul, asked for payment to become an Amul distributor and franchisee store, ran recruitment scams, everything they did in place of Amul. But later on, Amul won the case, and all these gradually vanishes away because Amul was a vigilant watchdog, and they really found that yeah, some companies are running using their small, uh, like words of the and using in their domain. That's why Amul sued them, and later on won all cases because that was a big brand. So, uh, it's very important sometimes that when the company has launched their own domain name, because after that they can sue for every company who is using their own domain. But before that, if somebody is there, like in the case of Nishan couldn't use their own domain. Why? Because already Nishan computer was existing. So this is the scenario. So how to protect the trademark from using by others? So in such cases, there is a like a particular body that is we can find all the domain names through WHOIS information, through which we can find out who are the similar domain names to us. And if we really find, we can really follow a simple online procedures administered by WIPO, that is World Intellectual Property Organization, and the body is Domain Name Dispute Resolution Board. So through which independent experts decides which domain name should be returned to you or to be cancelled. So yes, there is a proper dispute resolution board, and that takes care of everything in case of domain name dispute. So there are many bodies like this, but what is important is like we have to select a domain name very wisely. We have to register our domain name and check it regularly. Is there any similar one going on, or we are protected? Then we have to protect our domain name and trademark, making sure that nobody else can use them as their domain. And if required, we have to use all available legal means to get the domain name transferred to you or cancelled. Suppose somebody else is using, it should be transferred to us or it should be cancelled. Otherwise, it will definitely reduce our own revenue, or we might lose our reputation in course of time. And also, we have to do the IP audit of our website. Whenever we make a website, what is important is like we have to use the content that should be the point words. We shouldn't use anything which is already available, because everything available on net are not copyright free. We may fall prey of some copyright case. Then we have to control access to specific part of our website by encryption, online agreements, or conditional access system. So through which we can protect our website from getting infringed. Somebody might take random parts of our text, may get infringed, like may infringe our website. So in such cases, we have to use the proper channels to find out that our domain name must not be used. And if we are using some technical tools for making our own website, we have to take a license. First of all, we cannot use any technical tool as such to make our own website. We have to take the license or like proper agreements, then only we can use such technical tools also to avoid the infringements or avoid any kind of violations. In terms of patents, why? Because this is very important. Patent is a tool for our product enhancement. Whenever we have a patent right, it simply says that our product is novel, unique, useful, industrially applicable, and non-obvious. So it's definitely you can say that definitely a mark of our own genuinity and our own innovativeness. So once we have a patent right, our product value suddenly goes very high. So revenue generation itself become very easy because people trust us. Even like we can scale up technology transfer, commercialization is much easy with a patent rights. But important is like how to manage our intellectual property. So for any enterprise, any business, IP management is an essential tool. Why? Because there are many ways by which it could be infringed. So direct infringement or indirect infringement, both could be done. Direct means through literal words, any component, any process could be infringed. Equivalent products could be made to us doing the equivalence infringement. Somebody might be using some part of our product and inducing others to make the similar kind of total formulations, total products, compositions by inducing. So that is induced infringement. Or somebody else might be preparing like some part or contributing towards the infringement, means not the whole product but some part without which my own product cannot be made. So if somebody else is producing that, so it's a kind of contributory infringement. So any kind of patent infringement might take place even after the grant of the patent. So once we acquire our patent right, we shouldn't sit as such. We should have a proper vigilance over what is going on inside the market, and is anybody is infringing our product, or if they are infringing, definitely we should sue them, because it's a kind of violation of IP rights, and also our revenue generation will be lesser as compared to others, because others are also producing parallel to me. So this is the scenario. So how to search it? Exactly, we have to search for patentability search. There are many kind of patent search which are very important tool to avoid the infringement. What is important is like we shouldn't infringe others. Others must not infringe our product. And this could only be possible if we go for a proper patent search. So validity search, we should check like others patent, if they are really violating our or infringing our own product, then are they really valid? Their aim claims, are they valid, or they are just entered without any validity? We have to see how much part of our product is getting infringed, whether process or any component or all components, what is being copied. So we have to totally map our product with others product to see. And if they have a patent rights acquired after us, definitely it's our rights, because we have launched our product earlier to them, we have entered the market, we have the patent granted earlier to them, so rights goes with us first. Freedom to operate search is must. If suppose somebody is suing us for infringement, we have to see what are the legal boundaries, like which are really taken up by the patentee or the innovative products. So what is the part which are free to be operated, and what are the parts under which, suppose if I am operating, I will not be considered as infringing some other's product. So freedom to operate search has to be done. State of the art search is important, what is actually in the market and how we are different. So if we are like focusing more on exactly we shouldn't infringe, why? Because if somebody is saying that yes you are infringing, but I have to prove no I'm not. Why? Because uh, I have some portions which are very different to you, and these portions only I'm doing, that is not linked to you. So in such cases we should avoid any kind of litigation against ourselves, and very plain thing is that we shouldn't infringe others product intentionally. So this part is important. The Indian government, what is important in Indian Patent Office is like every patentee who has a granted patent in their hands, they must file the form number 27. So what is form 27? This is a statement of working of patents in India. They have to time to time submit a report that invention has been worked in terms of, yes, for the granted invention I'm manufacturing the product in substantial amount and making it affordable to the people of India. Public requirements are met because I'm producing a large amount, and I'm fulfilling the needs of the people. And I'm also giving employment to the people of India. Why? Because I'm manufacturing more in India. So this is the purpose of the Indian government. Like once a patent is granted, they must not go in vain. They must solve the problem of making it available at a reasonable cost, and also they must be manufactured in India. Make in India initiative should be promoted, it's important. But suppose somebody has taken a patent right and sitting with the patent right without manufacturing, or somewhere manufacturing but not in India, somewhere else, some in other country, so it is said to be not working. And in such cases, the patent rights are not considered to be valid, and in such case government may intervene and say you to give a compulsory license to some other company who is manufacturing the product or who can manufacture the product in India, and yeah, to make it available at a reasonable price. So this is important, like even the government doesn't want that every grantee must is sitting with the patent right. Patent licensing, that I have just said, licensing is renting of IP. This could be voluntarily or not voluntarily. Suppose an innovator, which is a student innovator or a faculty innovator, academician, who is like inventing something, but after inventing, what they have a patent rights granted, but then what to do? They can license this particular formula, this composition, to some company who can manufacture the product, and in return they can gain a large amount of royalty. So this is a kind of entrepreneurship where uh, not only it's not very possible for every innovator to establish their own firm, but this is a kind of IP licensing through which IP commercialization takes place. So suppose if I have a patent right granted, I can give this formula, this composition, this product, full formulation, full process to some other company, and in return I'm getting paid back. So these royalties are a very lump sum as a unit sold or as a lump sum. This is very attractive, especially for innovators, and this is a major way of IP licensing. But suppose I'm a firm already and have been granted a patent, but I'm not able to manufacture in India because of many reasons. And suppose for 3 years I have not done it. So in such cases, government may intervene, and after intervening, government may say that yes, you give your formula to other company and other company will manufacture. Sometime I don't want this to be done because this is my own patent rights, and yes, royalties or licensing royalties are not much as compared to when I already manufacture it. So in such cases, government may intervene and they may say to give the license to another, because government is not satisfied with my form number 27. They are not satisfied with my working. So in such cases, this compulsory license may happen. Another option is cross licensing. Means we are exchanging the IP. I have the IP rights with me, but I'm not very keen to produce in India, or I don't have the facility. I don't have so much revenue to start my manufacturing. Other company has IP rights of some other component which suits me. So in such case, suppose I want to manufacture something, but I don't have the patent rights. Some other company has. We can exchange the patent rights, so that is cross licensing. In such cases, I can transfer my IP right to some other company. Some other company will manufacture my product, and I will take back their patent rights of some other component, some other product, and I will manufacture that product. So suppose it suits me. I have the patent right, but the other product suits me more. So in such cases, cross licensing could be done. So it's a kind of collaboration without any risk of litigation, and there is no financial exchange between the parties. It's the exchange of IP rights. So suppose I am selling some kind of textiles, another has some food product patent. So we are exchanging, and now I'm producing food products, another is producing textiles. So this is another way of way of monetization of IP rights. So patent licensing is a very important part. I will happy to answer some questions because like this will be more important. So, okay. So, yeah. Khadim Shadi, is there any duration limit for trademark rights? Okay. So, yeah. Duration limit is for 5 years. Suppose for 5 years, if you are not using your trademark or your trademark is not visible on your products, so in such cases, like it may happen that you have to surrender the trademarks. That is important. So for 5 years, for patent it's 3 years. For 3 years, you have to manufacture in substantial quantities. Otherwise, you have to license it. Government may also intervene for licensing it. Okay, Jiva Balu, kindly highlight on domain registration procedures and website to register. Okay, so domain registration or website to register should be done by a proper license, licensing software systems or technical tools. I just said you like there are many websites which are offering it free, but there are certain terms and conditions we have to follow them, or it could be paid websites. So it should be totally license based domain registrations and website or domain. What is important here is like your domain must not match some other domain that is already in existence, or once you like prepare your own domain name, make it a very quaint term so that it must not match with other, and others also may not take it later. And once you register your domain name, be your own watchdog that you have to see, like others must not take up your own domain name in later course of action. So that is important. A trademark duration is 10 years. After every 10 years, it has to be renewed, but 5 years is the time. If you're not using it for 5 years, it's mismanagement of IP right. I can say that, and then government may intervene. You may need to surrender your trademark to some other company because many companies might be very interested to use your own trademark. Suppose if you're not using and sitting with just taking up the trademark, that is not good. That's why. So, Alka Saxena, we are from school. Students have filed patents which are commercially viable. Yes, definitely. Every student, whether it's a school or a college or a university or a researcher or a PhD student, must file at least the provisional patent once they have an idea in their mind. And within 12 months, they have to complete their product and file the complete specification with the claims. And later on, now, after filing the complete specification, they can get it published on the site of patent office and they can get it examined also. After that, it could be granted. So, and yes, I just told you there is a 80% reduction in the fees. So everyone should leverage the opportunity of filing a patent application at a reduced fee of, because it's just a 1600 through e-filing. So every even school student can afford it for a provisional filing. What is the Jiva Babu? What is the frequency of submitting Form 27? Is it every year? Yeah, for the first 3 years, actually, after getting the patent right, for the first 3 years, we have to show that I'm manufacturing. So, if for the first 3 years, normally at the expiry of before 3 years, you have to submit the first Form 27. Later on, you have to submit it on yearly basis. D. Paramsimam K. Can we license before the grant of filed patents? No. After grant only, it's suppose that you have the patent rights in your hands, and then only you can license. Because granted patent can only be talked about about the licensing. Nobody will believe you unless until you have a granted patent in your hands. That's why that's the scenario. Okay. Professor KP Kadalkar. When a product is licensed, who is supposed to keep a watch on infringement? Licensor or licensee? Suppose a product is licensed. So suppose you are licensing to somebody else. Now the other one is manufacturing, and the revenue goes to them actually. So if somebody is infringing, it's like important that one who has the license currently, they should have a watchdog, because you are just getting the royalty in return because you have already licensed it, and your royalty will be almost the fix and you are getting it on regular basis whatever you choose. But those who are actually manufacturing will be in threat because their revenue will go down if somebody else is infringing and preparing or manufacturing or selling the same kind of product. So it's not like affecting you much, but the person who has the license currently. Okay, Dr. Shwan Prakash Patel, what are the best ways to identify if someone is infringing our granted patent? Patent search. Once you go for a patent search, because unless until something is in public domain, you can't see it, because on websites only after publication of patent, they are on the sites. So that is about the patents who are infringing. But somebody suppose has not the patent rights, but still they are infringing your products. Then only thing is that you can have the Google alerts, you can have the technical tools. If you are visiting shops or malls, you should have a quick watch on what is exactly in market. Is it similar to you? Are they using the same kind of composition that you have patented or same kind of trademark that you have registered? Is there any text that you have copyrighted it and they are using on their labels? So everything you have to take in account. So in every company there is a proper legal section who looks after all such kind of infringements. And if infringement is taking place, definitely legal action can be taken. And all the patentee normally wins the case because infringement is totally illegal. Dr. SRM Krishna, after patent publication happened, what is the best approach to get the grant? Can you? Okay. So once you file a provisional, within 12 months, you have to file the complete specification with claims. From filing within after 18 months, suppose you have filed today, after 18 months, it will be published on the site of patent office and in the journal of patent office. Suppose you want an expedited publication, you can fill the form 9 with a fee of 2500 and it will be published within a week or maximum 15 days. So after publication, you can request for examination to the patent office by filling the form 18 and with a fee of 4,000 through normal process and 8,000 rupees for expedited processing. So unless until you apply for examination, patent office will never examine your patent application. And after examination only, they can either grant the patent or reject the patent. So this is the process. Yes, examination request must be filed within 48 months from the date of first filing. So 4 years, within 4 years at least you have to get it examined, because after that it seems to be abandoned. Okay, Dr. D. Varalakshmi Shiram, is licensing legal in India? What are the laws associated with licensing? Yes, licensing is legal in India, and licensing is done based on the mutual basis. Like what are the, but it's said that legally minimum 10% of total cost must be given as a royalty. That is said, that is a minimum. But suppose if mutual consents are not okay between two parties, so in such case, even government can interfere. Suppose if I'm requesting the other company that give me license because you are not working perfectly in India, your products are not being available at a reasonable cost, you are not manufacturing a substantial amount, and I'm requesting for a license to you, but you're not giving me. Or if you are giving me, you are asking for more royalties than required. So in such cases, I can connect to government, and government may intervene in giving me compulsory license. So in that case, that company has to give me compulsory license at a reasonable royalty. So yes, licensing is totally, and even like in many, suppose the case of Bayer versus Natco, that was a very important case where the two companies were not mutually agreeing on licensing, but then government interfered and taken up the license and given to other company forcibly. So this could also happen. Important is what government wants, that if you have a patent grant in your hand, you must utilize it. So that is the way. Either use it or you have to lose it. So if we are very happy after getting a patent granted, that's not actually the happiness. Happiness is there whenever we actually use the granted patent in manufacturing the product and bringing it in the market of India at an affordable cost and in substantial amount. So that really patents would be useful. So what's the purpose of giving the patent granted to innovators? The purpose is the manufacturing. So we should be ready to manufacture or to license it to some other company. That is the way through which we are also contributing. So other company will prepare the same product, and yes, they will prepare the product, and they will manufacture in substantial amount. And in this way also we are contributing towards the Make in India initiative. So yeah, so I'm really happy. I felt really happy to answer your questions. If you have any further question, you can definitely connect to me, and yeah, you can take my like you can have my email or LinkedIn ID. You can connect me for any further question if you have. So I think my time is up. Later on, if some more questions are there, I'll be happy to answer later on. So yeah, thank you very much.